Good morning and welcome to the Supreme Court of the United Kingdom. Today I am handing down judgments in two appeals, one Khan and Meadows and the other Manchester Building Society and Grant Thornton. A panel of 7 justices has heard these appeals, which raise questions about the application of the approach to ascertaining the scope of a defendant's duty of care in the judgment of the House of Lords in South Australia Asset Management and York Montague Limited, which I will call SAMCO, in 1997, in 2 very different circumstances. The first concerns clinical negligence, and the other accountants' or auditors' negligence. The 2 judgments which I am handing down should be read together. In the first case, Khan and Meadows, Ms Meadows in 2006 consulted her general medical practice to ascertain whether she was a carrier of the haemophilia gene. Unfortunately, the doctor negligently took blood samples to carry out tests which would establish whether she had haemophilia and not whether she was a carrier of the haemophilia gene. She was negligently informed that she did not carry the gene. In 2010, Ms Meadows gave birth to a son, Adjuwan, who shortly after his birth was diagnosed as having haemophilia. Genetic testing then revealed that Ms Meadows herself carried the haemophilia gene. If she had been told that she was a carrier of that gene, Ms Meadows would have undergone fetal testing for haemophilia during her pregnancy and would have chosen to terminate pregnancy if her son was found to have haemophilia. The High Court found the defendant liable for the costs associated with the condition of haemophilia and also the separate condition of autism. But the Court of Appeal reversed that decision, holding that the defendant was liable only for the costs associated with Adjuwan's haemophilia on the basis that the defendant's duty did not, in the circumstances, extend to exercising care to prevent the risk of autism. In reaching this view, the court saw the scope of duty principle, which SAMCO illustrated, as determinative. This court unanimously dismisses Ms Meadows' appeal. The court holds that the scope of duty principle, which SAMCO illustrates, applies in clinical negligence. Thus, Dr. Khan is liable only for the losses that fall within the scope of her duty of care to advise Ms Meadows on whether or not she was a carrier of the haemophilia gene. She is not liable for the costs associated with Adjuwan's autism. In the second appeal, Manchester Building Society and Grant Thornton, a firm of accountants, in 2006 and for several years thereafter, negligently advised the Building Society that it could prepare its annual accounts according to a method known as hedge accounting, and that these accounts gave a true and fair view of the Building Society's financial position. The Building Society relied on that advice to expand its business of giving lifetime mortgages and entered into long-term interest rate swaps as a hedge against the cost of borrowing money to fund that business. This method of hedge accounting hid the volatility in the Building Society's capital position and the severe mismatch which developed between the negative value of the swaps and the value of the mortgages which the swaps were designed to hedge. In 2013, Grant Thornton discovered its error and informed the Building Society, which had to restate its accounts, and the accounts as a result showed substantially reduced assets and insufficient regulatory capital. The Building Society remedied this situation by closing out the interest rate swap contracts early at a cost of over £32 million. The question in this appeal is whether the Building Society can recover damages from Grant Thornton, recover as damages from Grant Thornton the cost of closing out those swaps. Both the trial judge and the Court of Appeal held that it could not, and they based their decision on their understanding of the scope of duty principle in Samco. The trial judge held that if the claim had been within the scope of the defendant's duty, the damages would be reduced by 50% for the building society's negligence in their conduct of the lifetime mortgage business. This court unanimously allows the building society's appeal, holding that the loss fell within the scope of duty of care assumed by Grant Thornton, having regard to the purpose for which it gave its advice on hedge accounting. The court upholds the trial judge's 50% reduction in damages for contributory negligence. In each appeal, the majority judgment is written by Lord Sales and me, with whom Lord Reid, Lady Black, and Lord Kitchen agree. Lord Burrows and Lord Leggett each write concurring judgments in which they analyse the scope of duty principle in Samco differently. The majority judgment recognises in each case that there is no one correct way to analyse the tort of negligence, but considers that a helpful model to analyse the scope of duty principle within the scheme of the tort of negligence is to answer 6 questions in sequence. The first question, which I call the actionability question, is to ask, is the harm, which is the subject matter of the claim, actionable in negligence? The second question, which I call the scope of duty question, is to ask, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? The third question, which I call the breach question, is to ask, did the defendant breach his or her duty by his or her act or omission? The fourth question, which I call the factual causation question, is to ask, is the loss for which the claimant seeks damages the consequence of the defendant's act or omission? The fifth question, which I call the duty nexus question, is to ask, is there a sufficient nexus between the particular element of harm for which the claimant seeks damages and the subject matter of the defendant's duty of care, which has been analysed at stage 2? And the sixth question, which I call the legal responsibility question, is to ask, is a particular element of the harm for which the claimant seeks damages irrecoverable because it is too remote, or because there is a different effective cause, or because the defendant has mitigated his or her loss, or has failed to avoid loss which he or she could reasonably have been expected to avoid. The scope of duty principle is that a defendant is liable only for losses which fall within the scope of his or her duty of care to the claimant. This is addressed at stage 2 of the 6 stages. This principle predates Samco, but was applied and developed in that case by its application not to kinds or categories of damages as in the past, but to the quantification of damage. In some cases, the scope of duty question, when answered, also answers the duty nexus question, but in others, the latter question needs to be addressed separately after the court has determined that there is a breach of duty and factual causation. An analytical tool which is useful in some cases, but not all cases, is what is called the Samco counterfactual, which asks, what would a claimant's loss have been if the information or advice which the defendant gave had been correct? In Kahn and Meadows, the court holds that there is no basis for excluding clinical negligence cases from the ambit of the scope of duty principle. Applying the 6-stage model to the facts of the case, Dr. Kahn's advice was concerned with the specific risk of a child having haemophilia, and the law imposes on her responsibility for the foreseeable consequences of the birth of a child with haemophilia, but not consequences of the child's autism. In his concurring judgment, Lord Burrows emphasises the central importance of the purpose of the advice or information and asks whether it is fair and reasonable that the risk of a child being born with haemophilia should be allocated to Dr. Khan. He does not find the six-stage model, which he sees as novel, helpful or necessary in this case. Lord Leggett also concurs in the outcome, but puts greater emphasis on the causal connection between the defendant's advice and the claimant's loss. In the Building Society appeal, the majority judgment uses the same six-stage conceptual framework. The purpose of Grant Thornton's advice was to establish whether the Building Society could use hedge accounting within the constraints of the applicable regulatory environment to implement its business model. As a result of the negligent advice, the Building Society entered into the swap transactions and was exposed to the risk of loss in breaking the swaps when it was realized that hedge accounting could not be used. The Building Society was, as a result, exposed to demands for increased regulatory capital, which the use of hedge accounting was meant to avoid. That was the risk that the advice was supposed to allow the Building Society to assess, and which Grant Thornton's negligent advice caused the Building Society to fail to understand. The risk fell within the scope of Grant Thornton's duty of care. In his concurring judgment, Lord Leggett again emphasizes the role of causation and asks whether there is a sufficient causal relationship between what made the information and advice wrong and the factually caused basic loss. Lord Meadows' reasoning is closer to the majority, but places greater emphasis on the scope of duty principle as underpinned by the policy of achieving a fair and reasonable allocation of the risk of loss between the parties. In summary, in Khan and Meadows, the appeal is dismissed, and in Manchester Building Society, the appeal is allowed.